In a nutshell, expert evidence serves to assist courts and tribunals with understanding evidence on complex issues. Experts typically fulfill this role in stages. First, by preparing written expert reports setting out their opinions on the technical issues in dispute, with those reports being served on the tribunal and other parties to the arbitration. There may then be rounds of further exchanges of reports or meetings between opposing experts, but ultimately the expert's involvement often ends by giving oral testimony at the hearing, where opposing counsel, the tribunal, and sometimes opposing experts will have an opportunity to test the expert's views and put alternative competing theories or conclusions to him or her. There can be a temptation to think of expert evidence as simply the expert providing an answer to a technical question that has come up before the court or tribunal.
And so as we look at these individually, what we ask you to consider is this. The obligations on these different folks will vary, right? A fact witness is very much allied with the party to provide a detailed account of what happened. The party-appointed expert and the tribunal-appointed expert in this regard, allied in the same way together, their duty to the tribunal, regardless of how they were appointed. And that's an important thing to note. The IBA rules in general allow for appointment of both party-appointed and tribunal-appointed experts. Admittedly, tribunal-appointed experts, there is less use of this in international arbitration, but just to offer an opposite, the Prague rules, for example, suggest that the default would actually be that the tribunal appoints its expert, taking that inquisitorial and active role again with the introduction of the Prague rules. So just some things to consider as we walk through these three elements.
It is very important to keep a good paper trail. When I say paper trail, it can mean firstly, for example, the emails and your short messages through WeChat or maybe through WhatsApp. And also, if you have hard copies, keep them in good storage and to draft a good document management policy. So all these efforts on the paper trail will help you in the document production if certain dispute arises. And secondly, I think it's important to have a document management policy. Because, for example, sometimes the party may say that we have deleted all these documents, so I'm not able to provide it at this stage.